Ladies and gentlemen, this is Bruce the Moose with the Bruce the Moose Show. It is episode 0. It might be the first. It might be the last. Today we have breaking news. We are going to be reading the brand new filing in the Owens v. Maricini case in California. This is a DVRO renewal case, and we have a filing from the one, the only Lauren Knighty, Court of Random Opinion. In this case, this is the omnibus motion to strike irrelevant, false, and scandalous filings by David S. Gingras. In the alternative, motion to seal or redact non-party references filed by interested non-party Lauren Knighty movement. Okay, let's get into this filing. This is a wild back and forth. If you need some background on this case, go check out some of the other videos I've made. Go check out Lauren Knighty's channel, Court of Random Opinion. We may need to do something like 30-minute TLDR videos or 20-minute TLDR videos for both this, the Owens v. Maricini case, and the State of Arizona v. Owens case, just to have as a reference. Okay, maybe I'll work on that this week. Time is short, guys. We're doing our best. Let's get into this document that I just obtained. Notice of motion. Please take notice that on a date to be set by the court, or as soon thereafter as the matter may be heard in Department 405A, movant Lauren Knighty, a non-party to this action, will and hereby does move the court under Code of Civil Procedure 128A3 and the court's inherent and equitable authority for an order striking in its entirety the filings submitted by David S. Gingras, or, in the alternative, ordering redaction or sealing of references to movement. So Lauren just doesn't want to be a part of any of this, right? She wants to cover the case, but she doesn't want to be in the case, which I understand. Okay, here we go. Number 1, motion to intervene for sanctions and disciplinary referral. And 2, reply in support of motion to intervene for sanctions and disciplinary referral. Collectively, the Gingras filings. Ooh, it could be a movie title. I don't know. Next on Lifetime. Okay. In the alternative, should the court decline to strike the filings in full, movement moves under California Rules of Court 2.550-2.551 to seal or redact all portions identifying or discussing movement. Now, when they seal these things, do you think they print them out and roll them up and hit them with wax and a nice wax seal? I think they should. And then take a photo of it. That's what I would want if they were going to seal something. But anyway, let's keep going. This motion is based on this notice, the accompanying memorandum of points and authorities, the records and pleadings on file in this action, and any further evidence or argument presented at hearing. Very good. Memorandum of points and authorities. Number 1, procedural posture. The Gingras filings are set for hearing on October 10th, 2025. And if I look at my clock right now, it is October 10th, 2025. We are on the cusp of emerging events, guys. So stay tuned. Hit the subscribe button, hit the like button, all that jazz. October 10th, 2025, for which the court has issued a tentative ruling denying those motions. Ooh, a tentative ruling denying the motions. Ooh, tentative. We're a little tentative about it. Maybe on Friday we'll firm it up. You know, it's the end of the week. You got to get all your stuff done by the end of the week, right? So maybe you're just like, well, we're going to do a tentative thing, and then Friday before the end of the week, we're going to go away for the weekend and have a good time. So then it'll be solid. Maybe that's what's going on here. We'll find out today. Regardless of the court's ultimate ruling, the challenged documents are improper in their entirety. Ooh, improper. They are replete with irrelevant, false, and scandalous statements. The scandal. Oh, my stars and garters. Oh my gosh. I don't know that I have any stars or garters, guys, but they are just scandalized right now. Okay, scandalous statements about movement, a non-party. That's right. And serve no legitimate purpose. Yeah, I don't know why this guy keeps talking about Lauren in his filings. It's pretty irrelevant. So I agree with that. The court's tentative denial reinforces these filings are a misuse of the judicial process. Yeah, I mean, all the stuff this guy, Gingras, keeps filing in this case He says he's not even a litigant. He's not even Miss Owen's attorney. So why is he filing stuff? He's just trying to rack up legal bills or something for the other side. It's just bullying, intimidation, financial bullying. It's just rude. Anyway, that's my opinion. Section 2, background. 1. Movement is a healthcare professional and private citizen who produces commentary content on YouTube addressing legal and social issues. And sometimes we play Quiplash or Fortnite. It's all good, right? It's the American dream. You go on YouTube, you talk about a legal case in the court system, you talk about some societal issues, why everybody should have health care. You play some Quiplash. That's living the dream, right? Number 2, Movement is acquainted with attorney Omar Serrato, counsel for respondent. The tilted lawyer enters the chat, but their friendship is personal and unrelated to this case. They have not substantively discussed the filings, facts, or strategy of this action since Mr. Serrato became professionally involved. And I certainly haven't seen Mr. Serrato talk to anybody about this case in any way, publicly or privately. So I agree with this. Number 3, Movement and Mr. Serrato have participated in public YouTube commentary concerning a different matter involving Petitioner Owens. Those discussions were public, and note we're using the past tense here. That's very important. Okay, those were public, journalistic, and unrelated to this proceeding. That's fair. Movement follows several independent public social media pages collectively known as, quote, Justice for Clayton. Okay, so here, Lauren defines JFC as a loose group of social media pages, which I think is a far better definition or description than the one that Gingras gave in his filings, which was, you can't even figure out what it means or how you'd measure it or how you'd figure it out. So this is a little bit better. Okay, these pages, which discuss matters of public interest concerning Ms. Owens, her forthcoming criminal trial, and her various quests in civil court. She's on a quest. Is it a main quest or a side quest? I feel like her criminal case is probably her main quest right now, and she should be focused on that. And these things like DVRO renewals or giving quotes to the Daily Mail UK, these are side quests. And, I think clearing the quest log of the side quests would be a good thing for her to do. But anyway, in terms of just delete them. Okay, Movement has no administrative, managerial, or participatory role in any of these pages and is not affiliated with those who operate them. And neither am I. I don't run any, Instagram, Twitter, blog, wiki pages or anything like that. I'm not involved in any of that. I'm just sitting here in my new home office room, waiting for it to be painted so I can put up some wall decor and other things and kind of dampen the sound because it's a little echoey right now. Anyway, that's what I'm doing. I'm not, Lauren and I aren't running these web pages or whatever. Okay, where are we here? These pages are independent discussion forums, right? Independent, not a coordinated group or cult, as Mr. Gingras falsely claims. Yeah, he says it's a cult, but as we know, a cult is a organization, typically a small organization, that is consistent with the Bite model of authoritarian control or something like that, some other definition that would be consistent with that, so you can differentiate it and quantitatively define it and measure it and identify it. Gingras's definitions have never included anything close to verifying that there's an actual cult anywhere, let alone what that definition would be in his mind. So he needs to do a better job there. Number 5, Movement acknowledges that as a YouTube commentator who discusses legal topics of public interest, she may be a limited purpose public figure within that narrow context. Very good. However, that status does not permit attorneys to weaponize judicial filings to harass, defame, or intimidate. And certainly, if you go read Gingras on his old Twitter account or his new Blue Sky account, and even in some of his filings, he has this intimidation-oriented language. He has this bullying and intimidation style that he gets into when he's talking on the internet. Now, people say when he's on the phone or he's in person, he's sort of like this normal guy and he sounds kind of reasonable, right? But when he's on the internet, when he's writing these filings, he goes into, it's like Dr. Jekyll and Mr. Hyde kind of thing where it changes up and he becomes very rude and he starts bullying and intimidating and that. And that's my opinion on his language there. And I'm entitled to my opinion on that. Number 6, the Gingras filings falsely accuse movement of criminal conduct. Ooh, that's a heavy claim. Harassment and being a key cult leader. Key cult leader. Oh my gosh, that's absurd. I mean, cults are a serious business, and we don't want to make light of it, right? Because real cults that are actual organizations that you can define, find an org chart, find membership lists that are consistent with the BITE model of authoritarian control, that exhibit control aspects over their membership. Okay, they do real damage to people. They do real harm to groups and people, and so it's a serious thing. That's why I think they shouldn't be throwing the word cult around so cavalierly, right? But if it wasn't such a serious issue, I would go get a key cult leader t-shirt maybe. Anyway, and insinuate she engages in coordinated misconduct, all without evidence or connection to any issue rooted in reality or before this court. Yeah, he just sort of speculates. He says, what could potentially be possible? Could it be theoretically possible that something has happened here? Could it be theoretically possible that Judge Mata's dad influenced Judge Mata during the Owens v. Eckerd paternity case? If it's theoretically possible, I'm just going to assume it's true and argue about it. Like, what? You have to have some good evidence, sir. Anyway, number 7, movement has never had any contact with Miss Owens and had only one brief cordial conversation with Mr. Gingras. Oh my, cordial conversation. Cherry cordials all around. After which she expressly declined further contact. And I remember that. That's true. Instead, Mr. Gingras and Miss Owens deliberately and continually seek out and monitor a semi-public Discord discussion server, in which movement participates. Yeah, and she says semi-public here, which is pretty true, because it's a public Discord, but you can't just put a URL in your web browser and just instantly see all these messages or whatever. You actually have to go download the Discord app or the Discord program. You have to find an invite link. And then go sign up and create an account and all that jazz. So there's some work involved. If you don't want to see it, you just don't do this work, and then you just don't worry about it. That's what they should be doing, is they should just not be worried about it and ignore it. But of course they're not. So we've got that. Reviewing her conversations and selectively quoting them to portray her negatively in their litigation filings. Okay. 8, Mr. Gingras and Ms. Owens also routinely monitor movement's public YouTube commentary, even though they are under no obligation to do so. Yeah, I mean, it's not like Lauren is making a video and then emailing it to these people. Like, hey, by the way, here we go. This would be a push model, right? What we have here is what's known as a pull model. Gingras and Owens are seeking out and pulling things in. They don't need to. It's not being pushed at them, okay? She doesn't seem to understand when she calls about these, harassment cases or DVRO, OOP, IAH violations that she claims. She called the police when Clayton and Mike and Greg made an Instagram reel, okay, where they didn't even mention her name. Nobody sent her that. It's not. She went out and looked for it. Okay, it's not a push model. It's a pull model. And she doesn't understand the difference between these two things. It's just not very, there's nuance here. There's sophistication and nuance in process and language, and we need the experience to understand these things. Okay, anyway, they voluntarily expose themselves to speech they dislike. That's a good way to put it. They then claim to be harassed by it. Exactly. It's like the meme with the guy with the bicycle and a stick, and he shoves the stick through the wheel and flips over. And it's like, dude, you just did that to yourself. Why are you doing that? Anyway, their continued engagement with movement's online commentary, coupled with their refusal to disengage, undermines any suggestion that they are victims of harassment. Correct. Because they're pulling information, it's not being pushed at them in a harassing way. At best, their alleged distress is self-inflicted outrage, not actionable conduct by movement. Very good. Number 9, these accusations are false, irrelevant, and scandalous. Their only apparent purpose is to punish movement for exercising her constitutional right to free speech and to publicly vilify her through misuse of the court's docket. Number 10, the filings are therefore not legitimate pleadings, but an intentional abuse of legal process designed to harm and intimidate a private citizen under color of judicial authority. Ooh, very nicely worded. Number 3, argument. A, the court has inherent and equitable authority to strike improper or abusive filings. This court's power to strike the Gingras filings next on C-SPAN, arises from its inherent authority under Section 128A.3 to provide for the orderly conduct of proceedings and to amend and control its process and orders so as to make them conform to law and justice. California courts recognize that this authority includes the power to strike or disregard improper papers and to prevent abuse of judicial process. In addition, the court possesses equitable power to protect non-parties and interested persons from misuse of its docket. When filings are submitted for the purpose of harassment, defamation, or intimidation, rather than legitimate litigation, the court may strike them in whole or part, otherwise order their removal or sealing. And I think the intimidation is really what's going on here. Maybe, I don't know about harassment. Maybe you could make an argument for that. Defamation, I'm not so sure. That has a very legal definition. But intimidation for sure, in my opinion. Harassment, maybe, in my opinion as well. Okay, here the Gingras filings serve no legitimate procedural or substantive purpose. They are vehicles for personal attacks and retaliation against a non-party who engaged in protected speech. Exercising its inherent and equitable powers, the court should strike these papers in their entirety. Strike the papers! I've got the Snoop Dogg solo stove, like a fire pit kind of thing, out for my backyard. We could just strike the papers in there, maybe. I don't know. And just, smokeless with Snoop Dogg, right? Until he doesn't get smokeless, but that's a different story. But anyway, let's see. The court should strike these papers in their entirety to preserve the integrity of the proceedings and protect movement from further abuse. Very good. Section B, the Gingras filings are an intentional abuse of legal process. The Gingras filings misuse this court's authority by turning it into a platform for retaliation against a non-party critic. And we know Lauren has been very critical of all of the filings and stories and claims by Ms. Owens, as well as Mr. Gingras, so that's fair. They contain false and inflammatory claims, including that movement harassed Mr. Gingras and Ms. Owens, even though movement has never had any contact with Ms. Owens and had only one brief cordial conversation with Mr. Gingras, after which she repeatedly declined further contact. That's true. Okay, that is true about her conduct in this case. In truth, it is Mr. Gingras and Ms. Owens who have repeatedly sought out movement's online commentary, deliberately locating the Discord discussion server in which she participates, and monitoring her YouTube content. Having chosen to observe and analyze movement's constitutionally protected speech, they cannot credibly claim to be harassed by what they voluntarily consume. I agree. There are filings weaponize that self-selected content as part of a campaign of retaliatory abuse of legal process aimed at silencing criticism. Yeah, they're just fighting back against criticism when they should be focused on the case at hand, which is a DVRO renewal case. Okay. Section C. Movement's limited purpose public figure status does not excuse retaliation. Movement's public commentary on legal and social issues does not grant others authority to defame or intimidate her through official filings. Even limited purpose public figures remain protected from retaliation and abusive process. The First Amendment and Article 1, Section 2A of the California Constitution protect both the right to criticize and the right to be free from punitive misuse of the courts for doing so. Very good. Section D, the court's tentative denial confirms the filing's lack of relevance. And gosh, I didn't know there was a tentative denial. This is breaking news, guys. The court's tentative denial of Mr. Gingras' motions demonstrates that his underlying filings lack substantive merit. The personal attacks against movement are therefore doubly improper. They are irrelevant to the issues before the court and serve only to perpetuate harm and harassment against a non-party critic. Very good. Section E, alternate relief, sealing or redacting under Rules 2.550 through 2.551. If the court declines to strike the Gingras filings in full, Movement respectfully requests that the court order the sealing or redaction of all portions identifying or discussing her. And I recommend sealing with wax. You get the big wax seal and put a stamp on it. That would be pretty spiffy. As a non-party private citizen, Movement's privacy, safety, and protection from retaliation constitute overriding interests under Rule 2.550, Section D. The proposed redactions would be narrowly tailored to prevent ongoing harm while preserving public access to legitimate court business. Section 4, relief requested. Movement respectfully requests that the court, so this is like the conclusion here. Number 1, strike in its entirety the following filings by David S. Gingras under the court's inherent authority. CCP 128A3 and equitable powers as irrelevant, false, scandalous, and abusive. Oh dear. Okay, so we have A, the motion to intervene for sanctions and disciplinary referral, and B, reply in support of motion to intervene for sanctions and disciplinary referral. And I think those are both the two documents he filed that have like a screenshot of one of Lauren's videos. And my own selfie is in that thumbnail. Oh my gosh, guys, this is crazy stuff. What's happening here? Number 2, in the alternative, strike or redact all portions of those filings that reference or discuss movement. That's good. Number 3, alternatively, if striking is denied, seal or redact those filings pursuant to California Rules of Court 2.550-2.551. Okay, so there's it's like, hey, why don't you do this? If you can't do that, do this other thing. If you can't do that, do this. We're open to a lot of alternatives here. This is good. We're open-minded to these different ideas. Okay, number 4, grant such or other and further relief as the court deems just and proper to protect movement and the integrity of these proceedings from continued abuse of process. That's right. Similarly, in the Owens v. Eckerd paternity case, there was a February status conference, and the judge said, look, so the medical records don't get out into public domain when they don't need to be, even though the lawyers might need them. We can do things to seal or protect those medical documents, and the parties should not be releasing them, and we can protect them in the docket and all that jazz. So there are things that a judge can do. We've seen that happen before. So hopefully that'll happen here. In this case, dated October 10th, 2025. Very good. Okay. And then that's Lauren Knighty in pro per. And then we've got document number 2. Did you think there was going to only be one document here, guys? There's 2 documents. I'm giving you a 2-for-1 today. So hit the subscribe button, hit the like button. I don't know. It's TGIF. Have a cocktail on me. I don't know. But we got twins. We got twin documents all in one file. It's great. Let's read through it. Declaration of Lauren Knighty in support of omnibus motion to strike filings by David S. Gingras. So we read through the omnibus motion. Now we're going to read Lauren's personal declaration supporting that motion. So let's get into that. I, Lauren Knighty, declare as follows. 1, I am the movement and an interested non-party in this matter. I make this declaration in support of my omnibus motion to strike irrelevant, false, and scandalous filings. Oh boy. IFS. By David S. Gingras, or in the alternative, motion to seal or redact non-party references. I have personal knowledge of the facts stated herein, and if called to testify, I could and would competently testify to them. Very good. Number 2, I am a healthcare worker and a YouTube content creator who produces commentary on legal and social issues. My commentary occasionally involves public cases, but I am not, nor have I ever been, a party, witness, or participant in this case. Good background. Number 3, I have never had any contact with petitioner Laura Owens. I had one brief polite interaction with Mr. Gingras a long time ago. That was the extent of our interaction. I later made clear that I did not want to have further association or contact with him, a boundary that he apparently continues to struggle with. Oh boy. Yeah, he's still mentioning her to this day. I think over on Blue Sky. I think he even mentioned her in a YouTube video, which to my reading of the transcript of that video came across as threatening, in my opinion. Very inappropriate. Number 4, despite that, Mr. Gingras and Ms. Owens have gone out of their way to follow, monitor, and screenshot my online activity, including a public Discord forum and my YouTube commentary. These are public spaces, so I cannot stop them from watching, though one might expect Mr. Gingras, as a professional, to know, one might expect Mr. Gingras as a professional to know when to look away from things that upset him. Oh, did his feelings get hurt? Oh no. Ms. Owens continues to insist on listening to everything I have to say about her public proceedings, knowing that it will be unfavorable towards her. I mean, maybe she did. Did she do something right? Maybe. I'll try and remember something she did right. I don't know. I am declining to censor myself due to Miss Owens' lack of self-control or refusal to exercise it. I cannot stop Miss Owens from her self-destruction any more than I can prevent Mr. Gingras from continuing to accuse me of being part of a cult. Exactly. Well, I am here to refute the idea that there's any cult out there that is an organization consistent with the BITE model of authoritarian control. That's my job. That's what I'm doing, guys. I have 2 different videos in the backlog related to that. One of them was, I think it was the very first video I ever made when I started covering some of these cases on YouTube. So it's a pretty rough video, but it is there. Number 5, Mr. Gingras has now used my name, image, and commentary in multiple filings, asserting that I am a key leader of a cult. Key cult leader, Lauren, and that I harassed him and that I have been engaging in conspiratorial and criminal behavior. Oh boy. These claims are entirely false. They also suggest a troubling amount of time spent trying to criminalize the free expression of the online opinions of a total stranger. I think that's the crux of this whole thing, this sentence right here. There's a troubling amount of time being spent trying to criminalize the free expression of the online opinions of total strangers. That's a good way to describe this guy's PR strategy, some of his legal filings. Very good. I have never been arrested or credibly accused of a crime. While I interact with many others in my online commentary, this is what is commonly known as friendship. Exactly. Mr. Gingras' idea of a cult does not appear to be in touch with reality. That's true. And the problem is, language by itself, it's descriptive. It's not prescriptive. So you don't go to the dictionary and say, well, this word XYZ, it means this one thing and that's all it can ever mean and it can never change, it can never evolve. That's not how it works. It's not prescriptive. It's descriptive. So if the youth of America are out there, going 6, 7, skibbity Ohio, like this is just language changing over time. And, within that context, they know what they're saying and they're communicating with each other presumably clearly. I mean, I don't know, the youth of America, I guess they're clear to each other. Maybe not to me, but I'm working on it, kids. Let's see. Trying to figure it out. I don't know what 6, 7 means. Anyway, back to the point. The problem is when he calls things a cult or when Laura says it's a cult, it's like you can call a toaster an ice cream machine if you want to, but you're never going to get any ice cream out of it. So it's like a substantive problem in terms of communication when you are trying to intimidate or silence others by saying, well, you're just part of a cult. It's very dismissive, right? It's not intellectually honest discourse, right? So that's really what's going on here. He's looking at a toaster and he's calling it an ice cream machine. He's never going to get any ice cream out of it. And that's what I keep saying. Number 6, I have never harassed, contacted, or threatened either Mr. Gingras or Ms. Owens. The only ongoing contact is the kind they create by repeatedly seeking out my public content. To the extent anyone is providing unwanted attention here, it is not me. Very good. Number 7, I follow several public social media pages known as Justice for Clayton. There are multiple unaffiliated pages under that name. Yeah, you can go to a Instagram, you can go to a Reddit, you can go to a Twitter, you can go to wiki pages, Padlets. These, I don't even know who run half of these things. Obviously with the Padlet and the Reddit, there's moderators and those people are there. But things like the Instagram or the Twitter, I have no idea who runs those things. I'm not affiliated with it. They could all be different people. These could all be different people. Some of these people may not even like each other. We don't know. So it's crazy when Gingras and Ms. Owens lump them all together under a single dismissive label. Again, it's that dismissive label that tries to avoid a high quality discourse with an attention to detail and a high level of discipline, and just label things dismissively and throw them to the side to dehumanize individuals or groups of individuals. And it's really just terrible. Okay, I have no involvement in running or moderating any of them, and none of them are a cult. If they were, I assume we'd at least have matching t-shirts. Yeah, I mean, nobody tells me what to wear. If I want to walk around in a Hawaiian shirt all day, I'm going to do it. That's what I say. Anyway, ensconced in wood paneling. Okay, number 8, my inclusion in these filings serves no legitimate purpose. It appears designed to punish me for expressing opinions online, opinions that Mr. Gingras and Ms. Owens voluntarily consume, then claim to find distressing. Their filings weaponize their own voluntary outrage as evidence. Very astute there. Number 9, I am submitting this declaration not because I enjoy being dragged into litigation I have nothing to do with, but because I believe courts should not be used as a platform for personal vendettas against online critics. Accurate. The statements made about me are false, irrelevant, and professionally reckless, and I ask that they be stricken or sealed. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Okay, and we've got Lauren Knighty there with signature. And then at the end there was a, what the heck is this thing called? Proof of electronic service. Okay, but it's all just personal information, so I'm not going to show any of that. We could just enjoy redaction moves for a minute. Well, we let all that sink in, guys. What do we think about this? Lauren Knighty coming in hot in order to fight the irrelevant, false, and scandalous filings by David S. Gingras in the Owens v. Maricini DVRO renewal case out in California. This is a wild case, guys. I am going to try and cover this as much as I can when there's new material to cover. I have a backlog of topics I want to cover on my channel, so buckle up, hit the subscribe button, and we'll get to all that as soon as we can. In the meantime, it's TGIF. Go have a cocktail or a virgin cocktail or whatever it is you do on a Friday during happy hour. Enjoy the weekend to come, and hopefully some of these issues will be resolved by the court in short order. With all that said, I am Bruce the Moose. This is the Bruce the Moose Show from my nice new echoey home office. Thanks for your time, guys.